Viewers, 3 accused for staging anti-CAA protests that the police alleged led to the rioting in Delhi have been released on bail. This happened after the Delhi High Court intervened in the matter on the back of a petition and granted them bail. Devangana Kalita, Asif Iqbal Tanha and Natasha Narwal, who were arrested over a year ago under the stringent UAPA law, secured bail after High Court said that the state had blurred the lines between the fundamental right to protest and an act of terror. The Delhi police opposed the bail in the top court, but no relief came in. While the Supreme Court upheld the bail, the 2-judge bench said that the High Court's verdict will not be treated as a precedent. Now, this order has opened a Pandora's box, with many calling the anti-terror law's scope into question. Just for all of those who are tuning in and perhaps are not very well conversed with the details of the case, let me just go through some of them. The Supreme Court issues notices today to 3 Delhi riot accused released on bail. The ramifications of the High Court order on the UAPA cases to be examined. Top Court says High Court order shall not be treated as a precedent. The Solicitor General argued that the High Court verdict had turned UAPA on its head. The accused is now to file counter affidavit on the police plea in 4 weeks. So they've been given 4 weeks. Meanwhile, the Supreme Court refuses to cancel the bail of all 3 riot accused. Now, here are some of the observations that viewers, we must internalize. Number 1, reading down UAPA is an important issue and can have pan-India ramifications. This is what the Supreme Court said on the High Court order that was passed last week. Release of accused not interfered at this stage. It will be subject to a final order. So the stay on the bail continues. They are still free. Delhi High Court won't be treated as a precedent, the order passed by them, and shall not be relied upon by any party. What is troubling us, says the Supreme Court, is that 100 pages were written by Delhi High Court discussing the UAPA, which is the Anti-Terror Act, and the legality of UAPA Act was not even challenged before the Delhi High Court. So clearly, this is not found favor with the Supreme Court. The High Court, however, drew the line earlier. It said the state had blurred the line between the right to protest and terrorist activity. In its anxiety to suppress dissent, the state had blurred the line. Right to protest is not outlawed and cannot be termed as a terrorist act. If such blurring gains traction, democracy would be in peril. So this is what both the courts have said while granting bail, and of course the Supreme Court has not overturned that particular order but questioned the interpretations of the UAPA that the High Court engaged in. So let's open this up. We have with us noted lawyers and politicians, columnists, writers. Salman Khurshid today with us. Mr. Khurshid, this order by the High Court, of course, has led to a huge debate being stoked across the spectrum. Many people calling this a victory for liberalism, for freedom of expression, for the right to dissent. Why do you believe that the High Court, in granting mere bail to these 3 individuals, has actually passed a greater comment than what it was asked to look into?
Well, to tell you the truth, I think the outcome of the judgment in the High Court is something to be celebrated. I think the tone, the context and the result are all very, very welcome from point of view of people who believe in the supremacy of liberty. We all understand that liberty has limits, and there are reasonable restrictions that the Constitution places on liberty in any form. But the reasonable restrictions is not a carte blanche to just do away with liberty completely. Liberty causes inconvenience, we all know that. Inconvenience cannot be a ground of prohibition beyond a certain extent. And of course, this is going beyond any extent. It was not just prohibition, not just interference, but it was a very serious criminal act that they were accused of, and essentially an act of terrorism. Now, I think it was nothing short of absurd to impose a charge of terrorism in these circumstances in which these petitioners were charged. Having said that, if you ask me purely on a very, very technical way in which the courts operate in granting of bail or looking at appeals in matters of bail, they are advised to remain as pithy as possible, not to say something that would reflect on the trial one way or the other, etc. And therefore, I was a bit surprised that the court went into hundreds of pages to actually pronounce the judgment it did. But I think the court felt very strongly. It felt very strongly, and I think it's maybe more than a matter of technicalities and proprieties of judicial behavior. It was, I believe, the court felt that it was an underlying spirit of freedom that had to be protected, and therefore they may well have gone an extra mile. That's all I can say. I'm a little bit perplexed, and I haven't read the judgment, the order of the Supreme Court very carefully, but I'm a little perplexed and a little surprised that the Supreme Court said that this would not be treated as a precedent. I don't know what that means, that it would not be treated as a precedent. It hasn't stayed the matter, it hasn't interfered with the bail, but it has said that this will not be treated as a precedent. That could cause enormous confusion at the criminal bar.
Okay, let me bring in Mr. Aryaman Sundaram. Mr. Sundaram, you heard Mr. Salman Khurshid. Yes, the Supreme Court, I won't say has taken offense, but certainly has suggested in open court in its own order that the 8C verdict had turned the UAPA on its head, almost implying that from now on, the very strict stratification between the right to dissent and what is considered an act of terror, encouraging an act of terror, will be maintained, which, according to the Supreme Court, falls foul of the very brief that was being heard by the High Court. It should have limited itself only to the application of its mind to the bail matter. Do you believe the Supreme Court is today in its right to throttle the voice of conscience? I won't call it anything else. Maybe, as Salman Khurshid is saying, conscience appealed to the High Court judges and they went into this illustration. So do you believe that the voice of conscience has been throttled here?
Look, Rahul, I think, there is always a problem of reading too much into observations made by a court. Now, nowhere does the judgment, the order of the court, say any of what is being talked about. Nothing is there in the order. All that happened was that in the course of the hearing, the court says various things. Some of them, it's all a matter of loud thinking. Now, you will often find that various observations made by the judges during the hearing, the final decision is exactly the opposite to those observations. So I wouldn't lend too much store by those observations at all. But having said that, let's just come down to what the basics are. You see, there's a difference between a law and the application of the law. I don't think the UAPA as it stands has itself been challenged anywhere for it to have been commented on by the High Court. But having said that, it is a draconian statute, and draconian statutes have to be strictly construed. They cannot be construed liberally because they are very draconian by their very nature. Now let us understand the way that section is framed is that if a prima facie case is made out, bail shall be denied. Now, what does it do? It takes away the discretion of the court to grant bail. Whereas normally, bail is entirely a matter of discretion of a court. Under the UAPA Act, if a prima facie case is made out, that discretion is taken away. Now, that again might be a bit of an affront on Article 21 and the right to liberty, but that right itself under Article 21 has its restrictions. And when we are dealing with acts of terrorism, then to have such a stringent condition itself cannot be faulted. Having said so, what comes next is that the court necessarily has to see whether a prima facie case is made out. Now, the Supreme Court's observation that 100 pages were taken for it is obviously that the Supreme Court feels, at first blush, that much too much detail was gone into. But the fact is that as the Act stands, it does become the duty of the court to look into the case itself to see whether a prima facie case is made out. Why? Because it is this prima facie case which determines as to whether a person's liberty will be taken away without his right to even ask a court to exercise its discretion for bail. So this is a very, it's a very thin line between what is stating too much and what is stating too little, as to what has to be looked into for a prima facie case and what doesn't. And that the Supreme Court will finally decide when they're dealing with the matter. Like I said, I won't say too much store by the oral observations. There is one last and final point I want to make out here. You see, we have Article 19, which guarantees freedom of speech and expression. Article 19.1, while guaranteeing it, Article 19.2 restricts that right and stops making it an absolute right. The ways in which it can be restricted are found in Article 19.2 itself. 19.2 expressly specifies the heads under which the right of freedom of speech can be restricted. Outside those heads, there is no way that right can be restricted. Those heads are public order, incitement to violence, incitement to an offense, etc. Now, it is a fact situation whether in any case one of those Lakshman Rekhas have been crossed, and whether there is a public order problem, whether the freedom of the speech which is made is going to incite violence, is going to incite commission of an offense, is going to affect the integrity of sovereignty of India. In those cases, it would be bad. Now, I would like to say that unless an action can be found to be faulty under 19.2, I cannot see how it can be found to be faulty for the purpose of the UAPA Act. If under 19.2 it cannot be restricted, it would stand to reason that that kind of speech is not a speech covered under the UAPA Act. Therefore, these are all matters to be looked into by a court when deciding the matter. And the court will consider all these matters. As to how in the instant case it should be considered and whether it's been considered correctly or not, is now dependent on the Supreme Court, and one will see what the Supreme Court says. But I just want to point out, this basically is the ambit of what we're looking at. I personally can find no fault with the UAPA Act. The question is, its implementation could be faulty, but that is why we have the judiciary to correct it if it is faulty.
Okay, so one would assume, after what the High Court has said and labored on in 100 pages about perhaps the many misgivings it has read into the UAPA itself, that is a subject that is going to be considered later. But let's come back, Rajeev Chandrasekhar, to the point at hand, which is that the onus of establishing that there has been, in fact, an incitement to violence or rioting or, inflaming communal passions, etc., lies on the police. And when there is no material evidence, the police cannot conjure it out of nowhere, and the center is looking very bad in this particular circumstance. 3 individuals are out, and there are calls now being made to punish the police officers.
So Rahul, I think it is appropriate for me to remind your viewers and indeed all of us on this panel that it is just about 17-18 months ago that we were witness to these riots. We saw many people being killed. There was violence, there was incitement, there were police officers who were killed, police officers who were injured. And we all know that. And maybe for a few people in Delhi, 18 months on, the memories have faded. Maybe few of them include lawyers, judges, I don't know. However, crimes were committed. There were criminals involved. There were conspiracies involved. Charges were framed against many people who were involved in these crimes. And I want to point out, the lower trial courts found prima facie evidence against these three people and they were in jail for 1 year. The lower trial court found prima facie evidence. Even today, while the Delhi High Court may say that the police has not made a sufficient case under UAPA, many other charges under normal Indian Penal Code on rioting, inciting, preventing public servants from discharging the duty remain intact. On these charges remain and these people remain accused. So I don't want anybody to believe the spin about liberalism has won and therefore there was some attempt at suppressing liberalism. Crimes were committed. It is the duty of the police on behalf of all law-abiding citizens of this country to charge those who were involved in those crimes, and that is what was done. Now, the limited point that comes out of the Delhi High Court, as Aryama said very clearly, it is now for the Supreme Court to go into this and see what is the threshold test that UAPA charging must pass. What is the threshold? Is it under Article 19(2)? Is there supposed to be a harmonized standard between 19(2) and UAPA? That is a separate issue. But to make a case that these people are somehow acquitted, they are not charged with any crimes is wrong. It's factually wrong. They are charged with serious crimes. There was a serious crime committed in February 2020, Rahul. Everybody should remember that. And they will have to prove their innocence during the process of trial. So I have absolutely no problem if the court says they are entitled to bail. The Supreme Court has laid down in February 2021 the threshold conditions for bail. I have no problem with that. In any case, whether bail is something that people are entitled to under UAPA, the Supreme Court will now examine in detail. But we must not be under the impression that the police has failed, the prosecution has failed, or the central government has failed. The case against these three, as many others under the Delhi riots, the CAA riots, is intact. The trial will continue. As the trial courts have found, there is prima facie evidence that crimes were committed and these people have been accused with prima facie evidence.
Mr. Verma, let me come to you. Is the triumphalism premature? And is there today, on the back of this mere bail order, after all, they haven't been absolved of their alleged crimes, these individuals garnering a misplaced sympathy for an act which should actually attract the provisions of the UAPA and could even be classified as an attack on the sovereignty of this nation? That's what Rajeev Chandrasekhar is suggesting. Would you like to answer him?
You know, Rahul, the word triumphalism is the wrong word, I think, where we are talking about an essential strand in the warp and woof of what constitutes the democratic fabric. And that essential strand is the right to dissent, the right to protest, the right to have an opinion which is different from what may or may not be liked by the state. This right is sacrosanct not only in terms of the express provisions of the Constitution, but as an essential pillar of democracy itself. Now, for any regime which has a bent towards authoritarianism or relative intolerance to opinions which do not automatically endorse its views, the Brahmashastras available in their armory appear now to have become the UAPA and the sedition law. And their indiscriminate use, and I think the Delhi High Court judgment was a bit prolix, precisely because they were trying to point out that their indiscriminate use, where you conflate dissent with terrorism, or when you conflate protest with sedition, is a very lethal blow to the entire democratic infrastructure. The sedition law, for God's sake, was brought in by Thomas Babington Macaulay in 1837. Britain itself has removed it from its statute books in 2009. We retain it, but I don't know if it's a coincidence that there has been a 97% increase in sedition cases being filed after 2014. If a media report is made which is critical of the government, almost by reflex a sedition charge is filed. So these tendencies need to be curbed. In this particular case, there were protests against the CAA bill. I myself was expelled from the JBU for opposing the CAA bill to be implemented in conjunction with the NRC. Students, if they were protesting against that bill, that is their inherent right. A democratic discourse, if it does not take place, produces an unacceptable monolith. So they have the right to dissent. They have the right to protest. I am not condoning violence. Sometimes, as a consequence, intended or unintended, of the right to protest, there could be violence. And that is unfortunate and should be curbed.
Look, there are two ways of looking at it. And we've been speaking to some of the government's managers over prime time through the week. And some of them have said that, look, these three individuals are being positioned as the upholders of free speech in India to score a political point against the extant regime, that there are several state governments which have fallen back on sedition charges, that have curbed people's right to free speech. In the states, there are chief ministers who exercise discretion when it should not be. And there have been other regimes in the past. We had one spokesperson yesterday from the BJP who said that individuals who today are pointing fingers at us were collaborators in the emergency. And from there on, we have also had Section 66A. We have had sedition against thousands of people who protested against the nuclear power projects at Kundam. So why is this becoming a test case for India's democratic liberal traditions?
You can't give a timeline for test cases. You can't say that it was fine to suffer this in the past, but you can't suffer it now. You can't be self-congratulatory about your intentions and question other people's intentions. It doesn't matter whether it was Congress, the BJP, the Left Front, or any other party. There are some fundamentals about freedom and liberty that every party must accept and adhere to. There is no question that I would accept something because it happens to favor my party, and I would reject something because it happens to favor another political party. The bottom line is that if it's bad, it's bad. Constitutionally, it is bad. And what the High Court has done in a wonderful way is to say that there is a very clear line. Indeed, they've said there's a distance between terrorism and crime. They've not said that these people are wonderful people. They've not said that these people should be allowed to do anything they want to do. All they've said is crime is different from terrorism. So even if it's a heinous crime of murder, it doesn't translate into terrorism automatically. That's what the High Court has said. Now, there are other dimensions and aspects that the petitioners will have to answer, will have to combat, will have to fight and overcome. But that's not what we are on today. Today we are only on the use of UAPA by taking the guise of terrorism and trying to do with that something that is unacceptable, and that is muzzling dissent. If the dissent exceeds exceeds reasonable opportunity, then the dissent will have to be restricted and regulated. There is no problem there at all. But not with UAPA. And for somebody to say, Mr. Chandrasekhar to say, well, for a year they've been in prison, so there must have been a prima facie case against them. Well, I think it's a shame that they were in prison for a year, but it's a system, and we have to understand that the system cannot act immediately and promptly. It takes time, but the fact is that it took time doesn't matter. That we finally reached the destination to underscore liberty and the dominance and importance of liberty, I think, is the significant point.
Okay, quick reaction from you, Mr. Chandrasekhar. It's about punishing crime with a commensurate section of the law. They can't be overreached to send out a larger message to others who might disagree with you, that there will be very difficult consequences for you to face or suffer if you were to cross the line. And that's the intent here.
So, Rahul, while I don't disagree with the high-level points that Salman is making, I want to go behind the homilies, and I would like to suggest that just like he says everybody should unite about protecting the fundamental rights, we must also unite about the jointly defining what are the restrictions to those fundamental rights. The restrictions to the fundamental rights, the standards can't be different for Congress supporters, and suddenly those people who find themselves as paragons of liberty, but when they do something which is against Indian interest and Indian sovereignty, and it is okay when others do it. I think that this debate, Rahul, is really about what are the legitimate restrictions to these fundamental rights that our constitution guarantees. Now, Pawan went on and waxed eloquently about liberty and freedom of speech and all of that. But in January, February 2020, this was not about peaceful protest. This was not about dissent. This was about people dying. This was about inciting riots. This was about police people being killed. So let us not couch this in the same old liberal phraseology that this is all about liberty, this is all about freedom of speech. There are instances and exceptions to these fundamental rights. Our constitution provided for it. In 1967, when the parliament was given the right to write down and restrict these fundamental rights, in 1963, when Nehru was Prime Minister, they envisaged that these fundamental rights can be misused to attack the sovereignty of the country. So the time is now, and I will appeal to people like Salman and other people to come around and start talking about what are these reasonable restrictions to fundamental rights. And because these fundamental rights cannot be the cover under which people conspire to create instability, to incite riots, and then go out there and say, no, but I was exercising my right to free speech. I want to remind again, Rahul, through you to your viewers, in January and February 2020, it was not about some peaceful dissent. It was not about a right to free speech. It was crimes. People died. Lives were lost. Police people were injured and killed. There were crimes committed, and criminals have to face the consequences. Now, you can have an argument whether UAPA applies to them or not, and that is what the Supreme Court will rule on. But the fact is that these are not people who now are paragons of liberal values or freedom of speech or right to liberty. These are people who are accused of serious crimes under Indian law.
Okay, Pawan Verma, since you raised your hand, before I bring in Aryama Sundaram, yes, a quick response, sir.
You know, first of all, you cannot ever wax sufficiently or eloquently on liberty. It's our inherent right. So I shouldn't be accused of that. Secondly, I said that violence is to be condemned, but I refuse to believe that the entire protests against the CAA were ab initio violent, or they were intended to be violent, or they were consistently violent. There were large segments of that protest that were peaceful. And as violence occurred, it occurred from both sides of the divide, including state violence. My second point is, and this is a very practical point, Rahul, I'll take a minute only. You see, the way the laws are framed, there are under trial detainees which remain in jail for months, if not years, in a country which has made liberty a fundamental right. You just heard of the case of two people who remained in jail for 9 years before they were pronounced innocent. Now, the reason for that needs to be gone into. It's a practical issue, and Salman and Ariman are here, both from the judiciary. There is a 39% vacancy among High Court judges. A court like Patna, such a densely populated state, 56% of the judges bench is lying vacant. And in the lower judiciary, you have 38.5 million cases which are pending. In the High Court, there are close to 6 million cases which are pending. The way in which our judiciary functions, you have a situation where somebody, prima facie denied bail, once the case is made, lies in jail for long periods, deprived of his liberty. There's something inherently wrong here.
Obviously, it's highly condemnable. It's an anomaly that must be immediately corrected. It just flies in the face of anything that we would assume to be in consonance with the laws of humanity, or the principles of humanity. I just want to bring in Aryama Sundaram. Mr. Sundaram, look, let's come back to the subject here about the applicability of UAPA. Now, there are many people who come out and say that, today the medium is the message. That you can conspire against a state, you don't even have to hit the ground, you don't have to actually be physically part of any large gathering, demonstration, etc., but you can immediately, borderlessly even, through the ether, incite large-scale violence. We've seen it in some Middle Eastern republics in the past, in the last decade. We've seen it in different settings, in different countries. Sri Lanka, you've had communal rioting. In Myanmar, you've had ethnic violence. I mean, you don't need to be physically present holding a placard, that's what I'm trying to say, to incite violence. And therefore, today, when terrorists evade, or alleged terrorists, or call them what you want, to insurgents, or evade scrutiny by using multiple different fronts, facades, etc., how can we fault the state for applying UAPA? This is what, in essence, I think what Mr. Chandrasekhar was also suggesting.
Well, Rahul, I think it is completely self-evident that your physical presence is not required, a physical act is not required to incite violence. In fact, like I pointed out earlier, Article 19.2 expressly refers to incitement to violence. Now, that is a question of freedom of speech, which means the Constitution itself recognizes that speech is capable of being an incitement to violence, that you don't need somebody to hit the ground to be physically violent or otherwise. Speech itself is sufficient to incite violence. Now, the only problem I find in the UAPA Act, let's understand one thing. An act like that itself cannot be criticized. The reason being that one of the most dastardly things which we find in the universe today, in the country, world today, is terrorism. And terrorism where millions of innocent lives are at stake. And in order to achieve an objective, howsoever laudable or hateful the objective may be, to kill innocent people, to kill women and children, I think this is something which is absolutely dastardly, is something to be dealt with a very firm hand. And if UAPA seeks to do that, I can find no fault in it. Perhaps the problem is that what is terrorism for the purpose of UAPA needs to be more clearly defined, and that is what I believe that this judgment of the Supreme Court could do. In this particular case, the case which is pending, perhaps the Supreme Court would lay certain guidelines, would lay certain framework for what exactly would be terrorism and what would not. Because otherwise, we're giving too much play in the joint, too much discretion of judges, one judge may feel that a certain act is one of terrorism. Another judge may feel that that certain act does not come within the broad definition of terrorism. So I feel certain guidelines as to what would connote terrorism would be very useful in this particular case now that the Supreme Court has taken up the matter. Having said so, let's understand one thing, and let's not run away from it. I'm being totally apolitical about it. Anyone can say that any regime is trying to be authoritarian. But every regime in its own way does try to be authoritarian, irrespective of which party it is. To garner as much power as possible, to get as much power as possible unless under the available channels, is always something which is the role of the party in power. To cut into such powers and try to minimize such powers and to see that the power is not taken to that extent is the role of the opposition. So whoever is in power will try to take as much power as possible, will try to become as powerful as possible, and this is a very natural act. Therefore, we have the judiciary to ensure that acts which are well-meaning, acts which have a definite public purpose, that these acts should not be misused. And for that, we have the judiciary. Of course, we will always have a case of misuse. We always will. But we don't throw the baby out with the bathwater. When there's a case of misuse, it is for the judiciary to step in. Where I feel something can be done with the UAPA is to really define what exactly is terrorism through guidelines, through illustration, through examples, make it more definite and more within a straitjacket than what we find it today. But otherwise, I personally can find nothing wrong in the act itself. And if the act is misused, the judiciary is there to take care of it and should take care of it. As to the systemic problems of too few judges, well, this is something the whole country is suffering, not only with regards to the UAPA, but with regard to every statute, everything in the country.
We can have a discussion on that later.
That's a totally different point.
Yeah, I mean, that of course is a problem. It's an incipient one, and it's perhaps existed for many decades. We'll come to that later, perhaps at another time. But Mr. Khurshid, fundamentally, I want to ask you this, because that's where Mr. Aryama Sundaram is left off, that look, you can't throw the baby out with the bathwater. And you began by saying that you were a bit surprised that the Supreme Court sort of weighed in a little bit on the High Court and perhaps has sought to suggest that this should not become a precedent, i.e. the voice of conscience from which erupted the words penned in 100 pages that the High Court has sort of talked about. So perhaps it's a good thing that the Supreme Court is actually going there, and it should not be seen as, perhaps pressure being applied on the Supreme Court, as the tendency has been over the past few years, to side with the government.
No, I think the Supreme Court has no reason to be concerned about there being any pressure or being any expectation. Everyone respects the Supreme Court. Everyone expects that the Supreme Court would do what is the right thing to do. It will take time for the Supreme Court to hear this matter and finally pronounce its judgment. I was just saying that what worries me is at this stage to say something will not be a precedent means what? Does it mean that every High Court has to afresh hear this matter and come to a conclusion and not be able to say, since the Delhi High Court has already decided this, we will go along? That's what I'm saying, that it sort of doesn't really make sense to me. It puzzles me as to what would a High Court do. Another High Court would say, the Supreme Court says this is not to be a precedent, therefore we will not hear you, petitioner. Or will the High Court say, we will hear you, petitioner, afresh, and we may come to a different conclusion from the Delhi High Court because this is not a precedent. I'm just saying that this is not very tidy, that's all. And therefore, I feel a little puzzled.
Okay, final comments from Mr. Chandrasekhar. I think he's the only one who's raised his hand. Yes, final comments.
Rahul, just to take up from where Aryama left off, the reason I am very puzzled about people who don't want to characterize what happened in 2020 as terrorism is when two uniformed policemen, one intelligence bureau head, two policemen are killed, 25 people are killed, a serving police officer is threatened with a weapon. I consider that terrorism. I don't understand how that is a normal crime. I just don't understand how the Delhi High Court is characterized this as anything but terrorism. So therefore, I believe, I agree with Arima, if there is any ambiguity in the minds of some judges about what terrorism is, maybe the Supreme Court should weigh in and rule on this particular issue. And I'll say the last bit on this, Rahul. This is not about this is not a debate on free speech. This is not a debate on the right to dissent. This is a debate about when people incite and crimes are committed as a result of that incitement, should the law of this land hold them to account, yes or no? The viewers should decide, the country should decide, and I don't think this is about politics. This is about how a country like ours should be run.
I think that would be too simplistic. No, I think that would be too simplistic an interpretation, because the other side would say that this is very much a debate also about the limits on free speech, or perhaps the unfettered nature of what should be free speech. So I think we can't look at it from one particular prism. This is a conversation we've had today, viewers, a productive one. As you can see, we've exchanged ideas. This is a very, very significant issue and will go to shape really the way we see ourselves as a democracy also. And I'm leaving it at this, viewers. I'm leaving it at this. You've had the benefit of listening to a whole number of views, and perhaps you can take away whatever you want to. But I think we need to understand that this is a pivotal moment in defining what is dissent and what is actually not. We leave it at that.